This is ABC News legal analyst Royal Oakes welcoming you to Hinshaw and Culbertson's Insurance Law Program, where we discuss insurance and reinsurance issues of interest to industry professionals. Here's your host, the co-chair of Hinshaw's Global Insurance Services Practice Group, Scott Seaman.
Thank you for joining us on Insurance Law. In this episode, we look at a couple of more key coverage decisions decided so far in 2023. And we look at some cases to watch for the balance of the year. Our guest once again is the mighty Shane Dilworth, Law 360 Insurance Authority Senior Reporter. And the first case that we're going to discuss is from the Third Circuit, the decision in American Home Assurance versus Superior Well. I worked on some construction matters back in the day, Shane, when I was going through school, and my construction work was often described as being shoddy. So Shane, talk about this shoddy work case that was decided under Pennsylvania law.
I'm not sure if I'd agree with that assessment, Scott, but I'll absolutely tell you about the Third Circuit case. In May, the Third Circuit reversed a Pennsylvania federal judge's ruling that entitled Superior Well Services to coverage for $13 million in damages to hydraulic fracturing wells that was caused by the wrong mix of fracking fluid. The incorrect mixture allegedly caused reduced production from the wells owned by U.S. Energy Development Corporation. The Third Circuit's decision focused on whether the damages were the result of faulty workmanship, which is not covered, or if Superior Well performed its duties in a workmanlike manner. The panel came to its conclusion in favor of the insurer after looking to a 2019 ruling in Sapa Extrusions versus Liberty Mutual Insurance Company, as well as the Pennsylvania Supreme Court's 2006 ruling in Caverner Metals versus Commercial Union Insurance Company.
Well, Shane, and what's a problematic decision for me, the 11th Circuit, applying Georgia law, ruled an insurer is not entitled to recoup or obtain reimbursement for defense costs, even for claims that were not potentially covered. And I say it's problematic because every year I do a webinar on this, and one of my co-panelists disputes my statement that it's a majority rule that recoupment is allowed. And it's a very close call in terms of cases being divided across the country, but to listen on this case.
Well, you're right, Scott. The right to recovery is really getting to become a hot issue. This is just this ruling from the 11th Circuit just came about a week after the Hawaii Supreme Court heard oral arguments in a similar dispute, but we'll talk about that later. The 11th Circuit's July 13th ruling is likely to leave some carriers irritable because while it found that 2 CNA units did not have a duty to defend, it also held that the insurers could not recoup their defense costs. The coverage dispute dates back to a January 2016 suit brought against Winder Laboratories and its manager, Steve Pressman, by Concordia Pharmaceuticals, alleging that Winder made false and misleading representations about 2 of its irritable bowel syndrome drugs as generic equivalents to a drug made by Concordia. Continental Casualty and Valley Forge Insurance initially agreed to provide a defense under a reservation of rights, but later sued Winder and Pressman in Georgia federal court in 2019. The district court judge said a failure to conform exclusion in the policies relieved the carriers from their defense duties. The judge also found that the carriers could not recover their defense costs. The 11th Circuit agreed with both findings and concluded that the Georgia Supreme Court would not find that insurers have the right to recover their defense costs.
Yes, and so it's one of those situations where, in the absence of an express provision in the policy allowing or providing for recoupment, just reserving your rights on the issue is not sufficient to entitle an insurer to recoup defense cost on claims where it's ultimately found that there's no duty to defend. And so that takes us to some cases to watch for the rest of 2023. And you referenced that there's a case before the Hawaii Supreme Court to decide if an insurer or if insurers can recover the cost of defending non-covered claims in the so-called mixed claim construction defect suit. So what's up in Hawaii besides the surf, Shane?
Well, the Aloha State High Court is currently grappling with whether it should follow the Supreme Courts of California and Nevada in finding that Travelers, a subsidiary, and Phoenix Insurance Company can recoup costs they incurred in defending Bedell Construction Company in a suit over its use of embedded foundation straps at an apartment complex. The justices seemed a little bit perplexed during the oral arguments earlier this month with the idea of a policyholder being unjustly enriched when receiving a defense from an insurance company for a potentially uncovered claim. The dispute reached the Hawaii Supreme Court via certified question from a Hawaii federal judge who is currently presiding over the dispute. Currently, a majority of state Supreme Courts have found that insurers can recoup their defense costs from policyholders if a claim is not covered under a policy.
Shane, coverage for Superstorm Sandy is still being litigated. Tell us about the appeal before the Second Circuit.
Well, this will actually be the second time that the Second Circuit is going to hear this dispute between a Chubb unit called Great Northern Insurance Company and Madeleine Chocolate Novelties Company. After the case was sent back from the Second Circuit the first time, the case went to a trial and a jury found in favor of Great Northern on the claim of whether a windfall exclusion was applicable. In its recently filed opening brief, Madeleine Chocolate told the appeals court that New York federal judge Raymond Deary erred when allowing a jury to decide if it intended to have a windstorm provision supersede a flood exclusion to relieve the carrier for covering the full $53 million in damages the chocolatier incurred from the storm. Madeleine's policy had both a windstorm provision as well as a flood exclusion that had different anti-concurrent causation language, which carves out coverage if damages result from both covered and uncovered causes. The chocolate company contends that the judge's errant application of the Second Circuit's earlier ruling on the ambiguity of the flood exclusion allowed the case to reach the jury, which sided with the Chubb unit. Madeleine is asking the appeals court to vacate the verdict and allow for a new trial.
Yeah, and we talked before about the lead paint coverage cases that are out there, and I understand you have an update on the Ohio case.
Right, Scott. Briefing just started in the Ohio Supreme Court in a case in which carriers are challenging an appeals court's ruling that they're required to cover Sherwin-Williams' portion of a settlement to resolve a California suit over damages caused by the use of lead paint. I'm sure the Buckeye Supreme Court will again look at the question of whether this suit was brought because of bodily injuries like it did in the opioid cases. And I'm sure that that's going to be a very interesting case to follow.
Yes. Well, Shane, let's move to the South Carolina Supreme Court. And they're considering whether a product hazard exclusion or untimely notice relieves an insurer from contributing to the settlement of a take-home asbestos injury case. Tell us about this pending appeal.
Coval Corporation, which went into receivership in 2018, was in the business of installing, removing, and replacing insulation containing asbestos. David Rollins' father worked for the company and sued Coval in 2019, alleging that he developed mesothelioma as a result of exposure to asbestos from work clothes his father brought home. Coval informed Pennsylvania National Mutual Casualty Insurance Company about negotiations to settle Rollins' suit in 2020 and requested the carrier to attend the settlement negotiations. The insured initially agreed and offered to contribute some money towards the settlement, but eventually didn't. Coval's receiver then sued the carrier over its refusal, and Pennsylvania National countered that it was not provided with timely notice and that exclusions in the policy relieve it from its coverage obligation. The trial court sided with Coval's receiver, and the insurer is asking the Palmetto State Supreme Court to reverse the ruling.
An interesting case. And also it's a good chance for me to give kudos to my partner, Bill Bogdan in California, who scored a significant victory before the California Supreme Court earlier this month in the Victory Woodworks case. This was a secondary exposure take-home COVID-19 as opposed to asbestos case. And the California Supreme Court said that the employee's workers' comp exclusive remedy did not preempt the spouse's cause of action for her injury allegedly caused by her husband's presence at the job site. Then the court turned to the issue of, even though the employer obviously did not create the virus, didn't use it in its business, and the spouse had never visited the job site, whether she had to prove that there was some sort of special relationship with the employer to establish a duty. And the court said no, and therefore it went back to a 7-part test for duty under California law from the Rollins case. And most of those factors went against Bill's client, but a couple of them that ultimately the California Supreme Court relied on in holding that there was no duty included just the difficulty on employers to be able to deal with this situation of a general pandemic that it had no control over. It had no control over the spouse, and it also acknowledged that people may not be accurate in relaying information concerning where and how they were exposed to the virus. And the court also said that it would be an unreasonable burden upon the community as a whole and upon the court system if it was to impose or find that there's a duty on the part of the employee. So now California, like Wisconsin, Maryland, New York, and also Illinois, has ruled against plaintiffs in take-home COVID suits. So that's our first half wrap up. We're going to have Shane back early in 2024 to recap 2023 in its entirety. Our thanks to Law 360 Insurance Authority Senior Reporter Shane Dilworth, and we invite you to tune in or click on to our next episode of Insurance Law.
Thanks for having me, Scott.
The information on our insurance law program is provided for general information purposes only. Nothing stated on the program constitutes legal advice or creates an attorney-client relationship. You should consult directly with an attorney of your choosing if you'd like to obtain any advice with respect to any claim, case, or matter. Any views expressed are those of the guests and are not necessarily the views of Hinshaw Culbertson or any of its clients. For information on past and upcoming programs, visit the Insurance and Reinsurance page on www.hinshawlaw.com and click on Multimedia.